Call to order. It is 9:30 a.m. on November 16th, 2023, and I'm going to call this meeting of the Citizens Clean Elections Commission to order. With that, we will take attendance. Commissioners, please identify yourselves for the record.
Galen Payton.
Amy Chan.
And I'm Commissioner Kimball. We have a quorum, so we will begin. Item 2, discussion possible action on meeting minutes for October 26, 2023. Commissioners, you have the minutes from our October meeting in the packet. Is there any discussion on the minutes? If not, do I have a motion to approve the minutes? Commissioner Chan?
I move that we approve the minutes as written.
Thank you, Commissioner Chan. Is there a second?
Second.
Thank you, Commissioner Payton. I will call the roll. Commissioner Chan?
Aye.
Commissioner Payton?
Aye.
Chair votes aye. The minutes are approved, 3-0. Item 3 is the discussion possible action on the executive director's report. Tom?
Thank you, Mr. Chairman, commissioners. We did have an election, a jurisdictional election on November 7th. Hang on a second. So that you can see those results on our website. Just yesterday morning, Gina, along with Senator Bennett, the Pima County Recorder, and a local attorney had a panel discussion online through the Arizona Capital Times about how to get everything you needed to know about election 2024, which was a very good session. And I think we have a video of that, or there will be eventually, usually, if you want to watch that. But it was really content rich panel, and from talking to Gina, they had more questions than they could even get to, and so that was really success and leaving people wanting more. I also wanted to highlight the workshop that Avery did at the Tempe Public Library for National Civics Day. This was in conjunction with the Maricopa County Recorder's Office, and Avery's developed a presentation on civil discourse, and I live in Tempe, and so I had some folks who I know were there, and they gave it high marks, and so that was good to hear. We are continuing to host workshops for participating candidates every week, and we've had 27 candidates attend so far. I think we talked about this last meeting, but the governor's bipartisan election task force announced its report on November 2nd. It has a number of different programmatic recommendations. The one that obviously we talked about last time, which based on the reports from the last meeting that they had that made it in, was how we can utilize our website to develop more of a one-stop, or I think we're developed the framework for this, but to enhance the one-stop shop aspect of the Clean Elections website. There are some other programmatic aspects in the report, and then a couple of executive orders that the governor issued. We will have a hearing on December 13th on, just going to move on to the legal materials. There's a hearing on December 13th on the legislative leadership's lawsuit and motion for a preliminary injunction on Proposition 211. So this is a case that principally has to do with the legislative leadership. So the Speaker of the House and the President of the Senate's claims that the Prop 211, the statutory framework, violates the separation of powers principles, and a related concept called the non-delegation doctrine, which has something to do with how the legislature, or in this case, the voters who act as the legislature, can delegate certain powers to executive agencies. Mary is and her team have been working on this along with the AG's office. those are kind of the main things I wanted to mention on the report. I mean, those are really the highlights from my perspective, unless any commissioners have any questions.
Thank you, Tom. Are there any questions from commissioners on Tom's report? Okay, thank you, Tom. Item 4, discussion possible action on advisory opinion request 2023-01 from Service Employees International Union, United Healthcare Workers West. This agenda item represents our first advisory request under Proposition 211. The issue presented by the requestor is, does a donation, monetary or in kind, made to a ballot committee in support of its collection of signatures for ballot measure qualification efforts, support a covered person's campaign media spending as defined by the Act. The staff has prepared a recommended response that is in your packet. I'm going to ask Tom to summarize this document, and then commissioners, if you have any questions, I will turn to you. Tom?
Yes, thank you, Mr. Chairman, commissioners. So as Commissioner Kimball mentioned, the commission adopted a rule called R220 808, that provides for an advisory opinion process. The advisory opinion process is designed to allow folks who have a basis for doing so to ask the commission a question about whether or not a particular course of action will be, how that course of action would be treated under Prop 211. The purpose of that is to provide a framework in which folks who have an interest in can, get an answer to a question without having to have it only answered through some kind of enforcement process. And as part of that, it provides some protection to the person who asks if they abide by the terms of the advisory opinion. So in that sense, it's a transparent way to deal with legal and to some extent policy questions. And it does so in a way that rather than expanding in a particular way the commission's role, rather it really is a limiting effort and ensures that the commission's discretion is channeled into a transparent, formal process that folks can rely upon. And so with that, we received a request in late September regarding a discrete question of whether or not a ballot measure petition circulation would qualify as if you made payments towards that, would that qualify as campaign media spending, or if, as here, a donor opted out, right, which is to say, said to their the covered person or end spender, I don't want my dollars used for campaign media spending, but can those dollars still be used for ballot measure petition circulation? I know you all three commissioners who are here, I know you're all very familiar with the petition process, but just so, for the record formally, under the Arizona Constitution, voters themselves can initiate legislation, either statutory or constitutional. And there is a formal process that involves, printing petitions of the proposed legislation, circulating that text along with the petitions, and voters who are eligible to vote in that particular whatever jurisdiction, in this case statewide, are eligible to vote, can sign saying yes, I would like to have the opportunity to vote on this on the ballot. This is a heavily regulated area of political activity. The petition process is, the initiative process is. I mean, it's sort of, from my point of view, on its face, it's First Amendment activity very clearly. It's literally petitioning the government, and yet it's one of the most heavily regulated areas in Arizona political law. So the question, as I laid out, was, if you're going to pay for signatures, is that campaign media spending? And the analysis that we've recommended traces out the statutory terms, and two highlights of that. First, the definitions of campaign media spending in Prop 211 relate to public communications, and public communications is defined, to include billboards, television, internet, other things like that. And here, the advisory opinion request states that the requestor would not be doing any of those things or supporting any of those things. And it also says that if you were doing public communications related to a ballot measure, that would fall into the category of campaign media spending. So the upshot is, if I've said as a donor, if I've said I want to opt out from having my dollars used for campaign media spending, are these petitions themselves campaign media spending, essentially? And the staff's conclusion or recommendation for the commission is that they are not campaign media spending, because that discrete and heavily regulated on its own process of petitioning the government through those forms, that petition formal process, is not a public communication as defined in the Act. And thus, we think that the answer to that question is that is not going to, that course of action would be correct under the Act, that a person who said, I'm opting out, but nevertheless, this money, I think this money can be used for petition circulation efforts. We think the answer to that question is yes. We received 3 public comments on this point. All of those public comments reached the same conclusion. Some of their analysis was a little more perhaps elaborate than what staff believed necessary to answer this question. We think that the statute is pretty clear on it. I mean, we think the statute's clear as a bell on this. And additionally, some of the comments asked us to sort of explore some other issues, such as, well, what does that mean for opposition to a ballot initiative? And I think that we did not get into detail on other issues that might have been raised in the comments, but rather think that we answered the discrete question in front of you and provided an answer that we think is reliable, and we hope folks will rely on it, and we hope you decide to approve it.
Thank you, Tom. You mentioned some other organizations that weighed in on the advisory opinion, and I wanted to ask you about one of those from Statecraft that supported the advisory opinion, but seemed to then go into new areas, assuming that these would also be free of the requirement to report. And in their email, they said canvassing and field activities are intrinsically a direct face-to-face mode of outreach. They're not public communications. And similar face-to-face activities in opposition to an initiative or referendum effort should also not be covered. And I'm wondering your thoughts on that.
Yeah.
And it seems like that's a stretch from what the advisory opinion said. And I'm not sure that I'm comfortable letting that stand without some comment.
Mr. Chairman, Commissioners, I think that's a fair question. The way we chose to address that for present purposes was to take the advisory opinion's context on its face, and not really attempt to expand it beyond the discrete question asked. So the reason why, and this goes to your point, why I would not want to expand beyond the, I mean, first of all, obviously, if there was a specific question that we could be asked on this, we would consider it under the proper process. But under this process that we've outlined, I think it's important to understand that we would need to have a little bit more specificity about precisely what field canvassing means, what that kind of face-to-face interaction would mean in order for us to provide the kind of analysis that we think is here. In this case, the advisory opinion request itself, outlines with a level of specificity what is to be undertaken and what is to be excluded. And I think the process that we have put in place, which is parallels the Federal Election Commission's process in most respects. I think that we're better off in this place sort of answering the discrete question. There may be, again, I think with more detail, we could provide a more specific answer to that question now. But I think for present purposes, I think we decided, or I concluded, that we'd be better off answering the question in front of us. Obviously, I think it's helpful, I would say, to get a comment like that for the purpose of flagging additional issues, as you noted, that we will have to deal with at some point down the road. But at this point, we're not really in a place to do that.
Okay, it just seemed to me that the request for an advisory opinion was for a request on a narrow issue, and then Statecraft took that and expanded it greatly and almost said, and I'm probably taking this too far, but they almost said, because of what you said in your advisory opinion, we are assuming this. Thank you very much. And it seems like we need to say something that that you're bringing up things that were not addressed in the advisory opinion, and you shouldn't assume that just because you wrote a letter saying they assume that.
Mr. Chairman, I think that's a fair question. What I don't think we need to do, and I wouldn't recommend, is adding language to the opinion to say that, because what I would like to not have the opinions become is having to have a rebuttal of every single public comment that we have. But that said, I think that your statement is correct, and it's correct as a matter of the policy as stated. In other words, the policy expressly says, if you want to have something on which you can rely, this is the process to follow. And so I think this conversation itself makes that clear on the record to anybody who looks at it. Not to say that folks aren't going to make assumptions. Folks can make assumptions, but then they have to, right? That's the nature of making decisions. But yes, I take your point, and I agree that under the rules and the process we've outlined, we're not in a position to say to someone, you having asserted a point in a commission proceeding, then you now have some reliance interest. No, there is no reliance interest created by by a mere assertion.
Mr. Chairman.
Thank you, Ms. Carlson.
I would also just really like to emphasize that point by Mr. Collins, specifically that the rule that provides for an advisory opinion, R220 808, it's really limited to this. It requires the requester to provide specific facts, and it needs to be limited to that context. I think that just from a procedural legal standpoint, to be clear, advisory opinion should not start going outside the bounds of what was properly brought before under the rules.
Thank you. I guess my only concern, and I'm not a lawyer, is that by not saying anything about this, are they going to take it as an understanding that we agree?
Mr. Chairman, the thing what I can do, if this would satisfy you, I'm happy to, draft a communication to them that outlines that. I mean, I think that's perfectly reasonable. I think that what you've said captures the legal advice that Ms. Carlson has just given you, as well as my own recommendation on that point. And so I think that there would be no problem for us simply writing them a letter that says, hey, FYI, we considered your comment at some length in open session, and our position is, and if you have a specific question that you would like to provide, please do so. But otherwise, we're just not in a position to create. We want to dispel you of any idea that you have a reliance interest here.
Okay, thank you. Are there comments from either of the other two commissioners with us today? None. I also today, Mr. Barton is with us, who requested this advisory opinion. Mr. Barton, are there comments you'd like to make?
Mr. Chair, I don't have any specific comments, but I am here to answer questions if it's helpful.
Thank you. Do the commissioners have any questions of Mr. Barton? Okay, hearing none, is there a motion to approve the response to the advisory opinion request?
I would move that we adopt or approve the, actually, Tom, how should I phrase this motion? I'm so sorry.
I'm sorry, Mr. Chairman.
Tom?
Approve. Approve is fine. I mean, yes, it doesn't matter.
Okay. And it's the request or our response to the request that we're approving?
It's the response to the advisory opinion request.
Okay, that's what I thought. Thank you. I'm sorry. It feels like a Monday to me right now. All right, Mr. Chairman, I move that we approve the response to the advisory opinion request 2023-01.
Thank you, Commissioner Chan. Is there a second?
I'll second.
Thank you, Commissioner Payton. It's been moved and seconded that we approve the response to the advisory opinion request. I will call the roll. Commissioner Chan?
Aye.
Commissioner Payton?
Aye.
Chair votes aye. The response is approved 3-0. Thank you. Thank you, Mr. Barton, for coming.
Thank you,
sir. Item 5, public comment. This is the time for consideration of comments and suggestions from the public. Action taken as a result of public comment will be limited to directing staff to study the matter or rescheduling the matter for further consideration and decision at a later date or responding to criticism. Please limit your comment to no more than 2 minutes. Does any member of the public wish to make comments at this time? Does anyone on Zoom
It's like Rivco is right.
wish to make comment? Ms. Knox?
Thank you very much. Chairman, commissioners, Mr. Collins, staff. My name is Rivco Knox. I've lived in Arizona for years and years and years. I started out observing the commission because I think, as many of you know, and I have certainly said this in the past, the League of Women Voters, of which I am a longtime 50+ year member, was very instrumental in helping to draft the initial language and getting the initiative passed. And for quite a while, I think kept a close eye, was very supportive of the commission, various changes that were proposed, that some we opposed, some we didn't. As I think you know, also the League is a totally nonpartisan organization. I started observing because I was appointed as an observer by the president of the League of Women Voters of Arizona. I continued coming because I learned so much about elections as well as the role of the commission. And I've sat through some extremely interesting meetings, some very challenging meetings, some that made quite a few headlines. And like I say, learned a great deal, and have always been extremely impressed with the professionalism of all the commissioners, as well as with Mr. Collins, you and your staff. Nothing but pure professionalism. Always eager to hear comments, responding as appropriate. The reason I chose to speak this afternoon, or this morning, I guess, is that I noticed that the Governor's Office of Commissions and Boards, or I'm not getting the term right, has actually put on a notice seeking additional people to apply. And I just wanted to say that a number of years ago, I actually thought it might be my crowning kind of achievement to apply and be in the commission. And then I read all the requirements and realized, because of my partisan involvement, in addition to being in league, I was not eligible to apply. But I do know a few people who have. And I thought this was a good time for me to thank all of you commissioners. Some of you have been on for, it seems like thousands of years. I know that's not true, because none of us are that old, but it does seem that some of you have been around for a long, long, long time. You've never lost your commitment, your interest, your attendance is outstanding, your reading of the materials, your commitment to the purpose of clean elections. And even though your terms have expired, I just want to applaud you. I hope that new people will apply. I hope that new people will be appointed, because that's the way the process was intended. Nobody was intended to serve forever, even though some of you may feel like that. But I wanted to thank you, and thank you, Mr. Collins, thank all the commissioners, thank you, Mr. Collins, and all your staff. I've watched some come and some go, and they're all, again, very dedicated. I hope that new commissioners will be appointed. I hope they will be as dedicated and professional and nonpartisan and as committed to the mission of clean elections as all of you have been. I just wish you the best of luck. I do plan to continue to observe. By the way, I'm not an official observer on behalf of League, but I do write little reports that I send out to, 15, 20 people I know, almost all from the League, who are interested in knowing what's going on, because you do some outstanding work, and some of it gets in the newspapers, or the news, I should say, the media, and some doesn't. So I keep people kind of informed. So thank you. It's been a tremendous learning experience, and I'm not saying goodbye. I just thought with the new the request for people to be appointed to the commission, that it was an appropriate time for me to make some comments. So again, thank you, and I will be back. Bye-bye.
Thank you, Ms. Knox, for your comments and your kind words. Your opinions certainly mean a lot because of your longtime interest in the commission, going back to when this whole process was started. And I think I can speak on behalf of my colleagues when I say it does seem like thousands of years, but maybe not quite. If the process has started to find new members of the commission, I personally am glad of that, because this was not intended to be a permanent job, even though I think I'm in the 9th year of my 5-year term or something like that. But thank you very much, Ms. Knox, for your continued interest in our activities, and you give us a good perspective looking forward and also looking back. Thank you. Anyone else wish to make a comment? The public may also send comments to the commission by mail or email at ccec@azcleanelections.gov. At this time, I would entertain a motion to adjourn. Is there a motion to adjourn?
I'll make a motion to adjourn.
Is there a second to Commissioner Payton's motion to adjourn?
I second the motion.
A seconded by Commissioner Chan. I will call the roll. Commissioner Chan?
Aye.
Commissioner Payton?
Aye.
Chair votes aye. We are adjourned until next month. Thank you very much.